Now I want to introduce to you Dr. Jacqueline Sievert, who is going to speak to us about an overview of the judicial branch. Jackie is an assistant professor in the political science department at the Bowling Green State University. Go Falcons! She joined the department in August 2016 after 2 years as an assistant professor in political science and public affairs at Western Carolina University. Dr. Sievert's research focuses on understanding the relationship between independent judicial systems and conflict, protest, and rebellion in authoritarian regimes. She teaches courses on constitutional law, international law, political violence, and Middle Eastern politics. She earned her PhD in political science from the University of Buffalo in 2014. Please welcome Dr. Sievert.
Is this one working? All right, thanks. Thank you all for coming, and thanks for sticking it out to the end. I'll shout out my undergrad, too. I went to New York University, go Violets. Not as exciting as Bucks. And I have a master's degree from Dartmouth College in globalization. It's fitting that courts are at the end because Alexander Hamilton once referred to the federal judiciary as the least dangerous branch. The courts don't have the power of the purse, which means they can't fund any laws. They don't have the power to implement laws like the executive. But courts are a really important function of our federal government, of our state governments, and have a significant effect on our lives. So even though they are the least dangerous branch, they still play an incredibly important role. This is a brief overview of our court system in this country. It is fairly complex. I'm going to focus on the federal courts. I do believe next week there will be a focus on local courts and state courts, so I'm not forgetting about them. You're just going to get it next week. So our federal court system, the lowest level of our federal court system are our U.S. district courts. You might also hear them referred to as trial courts. These are the only courts within our federal system that have juries in criminal cases. All of our federal courts deal with federal issues, except occasionally the Supreme Court. So we have our U.S. district courts. These are our courts of first instance. So if you have a federal dispute, this is the first place you're going to file your case or your claim. They can hear criminal or civil cases in district courts. And we have 94 district courts throughout the country. Our next level of courts in this country are the U.S. Court of Appeals. In the Court of Appeals, if you are a litigant in a district court case and you want to appeal the ruling, this can go to the U.S. Court of Appeals. The U.S. Court of Appeals can also occasionally hear appeals from other federal agencies. So we just heard a lot about federal agencies. If they all have their own dispute mechanism within the agencies for the most part, and if you need to appeal a decision from a federal agency, this can also go to special courts of appeals. And then finally, we have the U.S. Supreme Court. Our U.S. Supreme Court has 9 justices. We have 1 Chief Justice and 8 associate justices. Currently, we only have 8 Supreme Court justices, right? We have a vacancy on our Supreme Court that we've had since last February. Last week we saw confirmation hearings to fill this seat, so it's likely that we'll see a vote and have a 9th justice soon, but we have been kind of, down a player for the last year or so. We have, as I said, we have 9 justices, 1 Chief Justice. All of our federal judges are appointed by the president and they are confirmed by the Senate. This is just a quick geographic boundary of our circuit courts. So we have 94, as I said, 94 district courts, and we have 13 circuit courts. We have 11 geographic courts. Then we have 1 Court of Appeals, a circuit court for the DC district, and then we have a federal appeals court where all these kind of federal agency cases go. At the circuit court level, so you'll hear circuit courts or Court of Appeals. These are used interchangeably. We like to make things really complicated in the court world. When you have a dispute in the district court, it is heard by 1 judge. It may also be heard by a magistrate who assists the district courts. We have incredible backlog in our federal court systems. So we have magistrates, which are actually executive appointees. And they assist the district court judges with some of the day-to-day issues of trials and dispute resolution in the district courts. Courts of appeals, if your dispute is heard at the Court of Appeals, you're heard by 3 judges, typically a 3-judge panel made up of members of the Court of Appeals. Occasionally, you can hear a full circuit, which is called en banc, which means your case is being heard in front of all of the judges in the circuit court. This is not very common. It takes a lot of time. It takes a lot of resources. So typically in the Court of Appeals, it's 3 judges that are hearing the case. Then at the Supreme Court, all 9 justices are hearing the case unless they recuse themselves. In the past couple of years, we've had a few recusals, mainly through Justice Kagan, because she had been the Solicitor General prior to her time on the bench, and so she's often recused herself on cases that she maybe had played a role as the Solicitor General. The Solicitor General is the main attorney for the U.S. government when they are appearing in federal court. So these are our circuit courts. The Ninth Circuit, you might hear a lot about this, particularly recently. The Ninth Circuit has made some pretty big decisions. The Ninth Circuit is our biggest district, our biggest circuit. It includes all of our western states, and there's oftentimes kind of movements or conversations about breaking up the Ninth Circuit. It tends to be a very large circuit. It has the most judges sitting on it. There have oftentimes been arguments for breaking that up and introducing another circuit. Congress can decide. Congress is the one that decides how many federal courts we have, how many districts we have, how many circuits we have, and so Congress really can decide what to do with the size and the scope of our circuits and our district courts. Okay. We have a common law system in this country, right? We allow our judges to interpret our laws, right? So if Congress is making our laws and the president and the executive branch is implementing or enforcing our laws, it's really the judicial branch that is interpreting our laws and telling us what the law is. We have what's called judicial review in this country. So the idea of judicial review stems from a really important court case, Marbury versus Madison, in which the Supreme Court determined that it had the authority to determine whether or not laws were constitutional. Right? So they can review laws that Congress passes, that the president signs. They can also review executive orders to determine if they're constitutional or not. And this is the bulk of the work of the Supreme Court these days. The Supreme Court has 2 types of jurisdiction: appellate jurisdiction and original jurisdiction. The overwhelming majority of Supreme Court cases are what we call appellate jurisdiction, which comes through that function that I just, that structure that I just showed. Original jurisdiction, we occasionally hear original jurisdiction cases. These are typically disputes, maritime disputes, disputes between states. We rarely see original jurisdiction cases anymore. Most of the work of the court is reviewing cases that have come up through the federal courts. The Supreme Court hears about 80 cases every year. They have applications for roughly 3,000 cases to hear every year. The Supreme Court gets to determine itself what cases it wants to hear. It can determine what cases it's going to rule on, and really gets to shape what issues they're going to hear at the Supreme Court. How do we get federal judges? Well, all of our federal judges are nominated by the president, and they are confirmed by the Senate. All the Constitution actually requires is that judges are appointed with the advice and consent of the Senate. Over time, this has really developed into the Senate voting on nominees. So the way that this works is the president typically circulates a short list of judicial candidates. Most of these candidates have been vetted by the American Bar Association. Usually they have served some time in the federal judiciary, either at the Court of Appeals level or the district court level. Occasionally we have seen justices that have not served as a federal judge. As I mentioned, Justice Kagan spent a lot of time as Solicitor General. We have a short list of nominees. But the president ultimately makes his pick and submits the name to the Senate. The Senate Judiciary Committee will hold hearings. They will hold meetings with the nominee. They'll hold hearings with the nominee. And then they hold a vote with the full Senate. Judges just need a majority vote to be confirmed. Hopefully most people have been kind of paying attention last week. We saw the confirmation hearings for Judge Neil Gorsuch. And one thing I want to point out about confirmation hearings is that we typically don't get a lot of information from judges in these hearings, right? As Russ mentioned in the last slide, a lot of times hearings, are pretty standard, and the people that are involved with the hearings know what kind of answers they're going to get. And I want to point out with federal judges or appointments to the Supreme Court, justices tend not to ever comment on cases. You'll hear lots of questions in the last week's hearing. We heard a lot of questions about Roe versus Wade. We heard questions about Citizens United, and Judge Gorsuch really said, I'm not going to comment on a case. I'm not going to comment on hypotheticals. This is very typical of judicial nominees. Most judges will never comment on a hypothetical case. Most of them will not comment on a case that they were not a part of, and they will not signal which way they would rule on a case if they were appointed to the Supreme Court. So I want to point out this is really pretty common in judicial confirmation hearings. Okay. One of the big questions about federal judges that we tend to talk about is the independence of judges, right? They are appointed by the president. Typically they have some sort of political preferences, or they have some sort of ideology that is in line with the president that appoints them. There are a lot of ways that the federal government steps that the federal government has taken to ensure the independence of judges. The first one that we think influences independence is lifetime tenure. So all of our federal judges can sit and hold their seats for their lifetime if they choose to. They can sit as long as they like, or they can retire when they choose to. The idea behind this is if judges don't need to get reappointed, if judges don't have to run for election, that they're going to be more likely to make decisions based on the legal facts in the case rather than outside political influence. So we do appoint federal judges for life tenure. In the state of Ohio, we actually have judicial elections, and so I can talk a little bit about that in questions about how this works at the state level. The other big key piece that we think influences independence is salary. All of our federal judges get a set salary that is set by Congress, but this salary can never be reduced. So once they are given a particular salary, it can increase, but it can never be decreased. So there are ways in which the court is protected from political influence. Right? Judges can't be removed unless we're talking kind of really egregious criminal behavior. It's really difficult to impeach a judge. They can sit in their seat, and be protected from political influence. That's not to say judges don't have political preferences. We know that judges are human beings. They're involved in our political system. They do have political preferences or preferences over particular issues. However, as we've seen over time, the ideology of the court has not actually changed all that much. So I want to show just a couple of graphs. This is the ideological leanings of all of our Supreme Court justices. This is from 1935. So the higher up are the more conservative justices are. Towards the bottom, the more liberal justices are. And so over time, right, our ideology in our modern court has actually stayed relatively the same, right? We have some periods of conservative courts, we have some periods of more liberal courts, but from the 1930s until the present day, our ideology of our justices has stayed pretty much consistent, with the exception of Justice Douglas. He's a really pretty interesting guy about what happens there. And if we look at our modern court, so this was our current court before the death of Justice Scalia, and again, towards the top are our more conservative justices, towards the bottom are our more liberal justices. And again, we kind of still see fairly consistent voting patterns based on our justices. So even though we know justices are political, we know that they're political actors, they have preferences, their ideology does stay pretty consistent over time. Okay. So how do you get involved with a federal court if you don't have a federal dispute, right? Hopefully many of you do not have a federal dispute or need to be involved with a federal court case ever. There's still lots of ways to get involved. So the first way that I want to just point out is the Washington University School of Law has a Supreme Court database. So if you go to that website up there, you can actually look through all of the opinions, all of the issues that the Supreme Court has ever heard, and it breaks down what judge, what justice voted on the issue, which way did they vote, what issues were involved in the case. You can go through, if you click on that analyst, the analysis tab right in the middle, the analysis tab right in the middle, you can actually search for particular issues. So if you're interested in environmental issues and you want to know how the court has ruled on that, if you're interested in federalism and you want to know how the court has ruled on that, that middle tab right there, you can just plug in your interest and it'll pull all of the Supreme Court cases that are on that particular issue. So if you want to do some historical analysis of courts, that is a really great way to get involved. The other website I want to point out is called SCOTUS blog. And this is a website that is updated all the time on current cases pending before the Supreme Court. If you go to that second tab in merits cases, you can see all of the cases that are pending before the current court and all of the briefs that have been filed in the court up until that point. So you can go through and look at what both sides of the dispute have filed, and they will link to OIA, which is a website that tracks all of the oral arguments of the court. So you can actually listen to all of the oral arguments that have been heard by the Supreme Court. So these are really two fantastic websites to pay attention to if you're interested in issues that are pending before the courts, what the court is doing. These are two really great websites. Another thing that's on SCOTUS blog is actually their full calendar. So you can see what days orders and opinions will be announced, when they're having arguments, when they're having conferences. So if you're interested in cases that are coming, we know on Monday we're probably going to get some orders and opinions on cases that have been heard this year. So two great resources to get involved, to pay attention to what's happening in the federal courts, hoping that you never actually have to be in a federal court. All right, so I think we have some time for questions. '51, unless the Democrats decide to filibuster. So all judicial nominees just need a simple majority. If they need 60 to end debate. So typically, right, if there is a filibuster, then he needs 60 votes to close debate and actually be confirmed. I will say the overwhelming majority of Supreme Court nominees are confirmed with very high of vote share.
I could just scream. Given that, okay, hello. Given that we have a Supreme Court nominee up, what would be his responsibility if matters dealing with the current president come before him? Would he be required to recuse?
It's unlikely that he would recuse himself. So Judge Gorsuch comes from the Mountain District. He's coming from the 10th Circuit. It's unlikely he would have to recuse himself in a matter where President Trump is a party to a case, or the administration is a party to a case. The only times when justices tend to recuse themselves is if they have worked specifically on a case. So in the case of Justice Kagan, she defended much of the legislation in federal courts. So those are the times where she's recused herself. But justices tend not to recuse themselves if they are hearing cases with the administration that appointed them. Typically not.
I would never make a game show host.
We've heard some about the confirmation hearings, and we've probably seen some of the information we're not getting. I'm wondering what kind of information can we expect from a candidate in the confirmation hearings?
So I will take Russ's cynical answer. Not much, really. Confirmation, In the typical nomination, not a lot of information. Most of the questions tend to be about cases they have decided on, previous cases that they've ruled on, previous cases that they've heard. A lot of the questions from Senator Franken to Judge Gorsuch dealt with a business case that he had decided about a trucker. So, you know, kind of pushing them on past decisions and why they made decisions in particular cases, particularly controversial cases. That's the area where you're most likely to get kind of illuminating information, is when they talk about their judicial reasoning, their judicial philosophy. But in terms of what they would say on a new case, you're unlikely to get that type of information. I will say the other area where we can get information about judges in their confirmation process is if there are discrepancies about their character, or there are potentially issues in their past, and the committee decides to bring in witnesses. I think probably the most well-known one is Clarence Thomas and Anita Hill, and issues that about his character in those confirmation hearings. But there's not much that's going to come out in a confirmation hearing that you know, close watchers of judges don't typically know already.
Let's thank Jackie for her information very much.